Yeah. Shall I start, madam?
Yes,
Well, I know.
sir.
Sir, namaskaram.
Sir, namaste. Good evening. Shall I start, sir?
Please start.
Yeah. My supreme namaskarams to Honorable Padmanabh Garu and his daughter, Madam Shailaja Garu, and best wishes to all the other students who are attending it. We have been discussing since yesterday, since last week, about the functioning of judiciary in India. I hope that you must have had an opportunity of going through the contents of the video that was already recorded last week, last Sunday. So with this feeling in my view, I would like to continue to speak on the several aspects of functioning of judiciary in India. As a whole, judiciary or judicial system is established to do justice to the needy. We already had a discussion of hierarchy that is there in India to deal with the various types of cases that are there and that will come forward before the courts. What we need to understand is what is the outcome of various provisions of the Constitution in practice in getting the justice or in doing the justice. Functioning of judiciary is threefold. One is what are the provisions that are there in the Constitution and other various laws that are dealing with the functioning of judiciary, we have to look into at first. Then whether in view of the system which we have, what are the difficulties that are being faced by the common man or the persons who are working in the judicial system in order to deliver the justice to the needy. Apart from that, we also need to understand how best the mistakes or difficulties have to be rectified for doing justice to the needy. For this, we must look into the concept and some of the principles that are there, that are adapted by us to do justice. For this, we have to first understand the then circumstances when we had created the Constitution and adapted it. Unless and until we understand the Constitution, we will not be able to understand the functioning of judiciary. The other day, we discussed about various introductory parts or aspects of judiciary. So, in the last meeting, after we discussed about Supreme Court and other courts, and also how the system is functioning, we have understood that the Indian judicial system has been established basing on the system of common law system, recorded judicial precedents, because it is inherited from British colonial legacy. So the court system of India consists of Supreme Court of India, which is the highest court in our country, and under it the high courts and the subordinate courts at district, municipal and village levels. So we also understood about the hierarchy of courts. We also understood that the Indian judiciary is divided into several levels in order to, for what? To decentralize and address the matters at the grassroots levels. How to decentralize? What are the methods adopted? And how the grassroots level matters are being addressed. You know, at highest level, Supreme Court is there. It is the apex court of the country. On 28th January 1950, it is established. You have to read articles 124 to 147 of the Constitution of India. But unless and until we understand this 124 to 127 of the Constitution of India, we can't understand what is High Court, what is Supreme Court, and what for it is there, and how and why it is the apex court and highest court of the country. So for this, let us understand in few minutes about the functioning of Constitution. For this, we need to understand at first about what the Constitution wants to achieve. The Constitution wants to achieve, as expressed in the preamble of the Constitution, so far as the judicial system is concerned, it wants to secure to all its citizens justice, social, economic, and political. It also wants to have the liberty of thought, expression, belief, faith, and worship, and equality of status and opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. This is what the Constitution wants to achieve. Then how it wants to achieve? Through social revolution. What do you mean by social revolution? It means that every citizen of the country shall have proper food, shelter, and freedom of speech. Not right to speech, freedom of speech. Freedom of speech means you have got the freedom to speak, but you don't have right to speak. Why you don't have right to speak? If you have got the right to speak, then the others who are hearing or who have to hear your speech must have a duty. If you have got a right to speak, then all others are under an obligation to hear what you say. So you don't have any right to speech, but you have freedom of speech and expression. And that is given as an object by way of mentioning in the preamble by stating that liberty of thought, expression, belief, faith, and worship. So after understanding this concept of social revolution, you must also understand about how you want to achieve that social revolution through the process of concept of democratic system and democracy. In democracy, all are equal and every person must get justice. For this, what you need is a law that is implemented properly by the courts established in India. So, in the Constitution, we have Chapter 4. Chapter 4 deals with the Union Judiciary. Chapter 4 deals with the Union Judiciary. This is from 124 to 147. You can note down. This is about Constitution of India in respect of the Union Judiciary. Then in respect of the states, we have got the high courts in the states. This is chapter 5. Chapter 5. It deals with articles 214 to 1 minute. 214 to 237. 214 to 232. Then we have got chapter 6, subordinate courts, that deals with appointments of district judges. Appointment of district judges. So you have to read chapter 4, chapter 6, chapter 5. Chapter 4, 5 and 6. If you read these articles only, you will be able to understand what is judiciary and how it functions. Let us see in chapter 4 today about the Union Judiciary. What do you mean by the Union Judiciary? It is in respect of Honorable Supreme Court. Chapter 4. I am reading for the benefit of all of us, Article 124. It says, establishment and constitution of Supreme Court. How a Supreme Court was established and what is the constitution of Supreme Court. This article says clearly, there shall be a Supreme Court. It means a Supreme Court means only one Supreme Court. It consists of a Chief Justice of India, and until Parliament by law prescribes a large number of not more than 7 other judges. Originally, this 7 now amended and made as 30. I understand now it is 33 or so, whatever it is. So you can appoint more than 30 or 33 judges of Supreme Court if the Parliament makes a law for it. Until then, we have one Chief Justice and one Supreme Court consisting of a Chief Justice and judges not more than 33 or so. Who has to appoint the Supreme Court judge? The President of India appoints by warrant under his seal and under his hand and seal, but on the recommendations of National Judicial Appointment Commission originally, but that is now not there due to several things. So a judge of Supreme Court, after appointment, he works till he attains the age of 65 years. So he will have to retire by the time he attains the after he attains the age of 65 years. So now we understand, as per Article 127, 124 of Chapter 4 of the Constitution of India, only one Supreme Court has to be established, and that was established. It consists of a Chief Justice and judges not more than 33 or so, subject to correction. And Parliament may by law can amend the law and appoint more judges to Supreme Court, and they shall hold the office until they attain the age of 65 years. Then it prescribes about the qualifications for appointment of a judge of the Supreme Court. First qualification is he must be citizen of India, and he must have any one of the three qualifications. Either he must have worked as Judge of High Court of India or any state for a period of at least 5 years, or he must have been an advocate of High Court or any other courts for 10 years, or he is a distinguished jurist. So the qualifications for appointment of a judge of Supreme Court is, first qualification, he must be a citizen of India, and he is below the age of 65 years. That means he did not complete 65 years age. Then any one of the other three qualifications. One is he is a distinguished jurist, or he worked as Judge of High Court for 5 years, or advocate of a High Court for 5 years. With this, we can understand that in Indian judiciary, only one Supreme Court, which is the apex court, and then a Chief Justice and other companion judges of 33 members must be there. And sometimes when Chief Justice office of Chief Justice of India becomes vacant by any reason, then the duties of the office shall be performed by any one of the other judges of the court, Supreme Court, as the president may appoint for this purpose. Then another important thing is the Supreme Court of India shall sit at Delhi, or in such other place or places as the Chief Justice of India may, with the approval of the President, from time to time appoint. And the Supreme Court of India has got a power to punish for contempt of itself, and it is a court of record. It must have all powers as a court of record, as a apex court, as highest court, including a power to punish for contempt itself. And the same is dealt with under Article 129 of the Constitution of India. Then we already discussed that the Supreme Court is having power of original jurisdiction. Original jurisdiction means it can entertain a dispute, any dispute directly. What are those disputes? If a dispute is between the government of India and one or more states, then, or if it is between the government of India and any state or states on one side and one or more other states on the other, or between the two or more states, it is in respect of legal rights of the states or union, whatever it is. So Supreme Court, as per Article 131, has got original jurisdiction. Then it has got appellate jurisdiction as per Article 132 and 133 and 134. Appellate jurisdiction directly from high courts on civil side and criminal side, and also in some other matters as per Article 132, 134. Then in some cases, Supreme Court has got power to give special leave for any other cases also to file it before it. And Supreme Court has got power to review its judgments or orders. And it also has got power to enhance its jurisdiction. Jurisdiction means two types of jurisdiction. One is pecuniary jurisdiction and another is territorial jurisdiction. Pecuniary means monetary. Territorial means the area. In respect of these two, the Supreme Court has got power for enlargement of its jurisdiction under Article 138 of the Constitution of India. And it also got ancillary powers. How? It is the Parliament which has to make necessary law, making provision for conferring upon the Supreme Court some incidental or supplemental powers, but they shall not be inconsistent with any of the provisions of the Constitution, provided they are needed or desirable or necessary for the purpose of enabling the court more effectively to exercise the jurisdiction conferred upon it by or under this Constitution. Sometimes what happens, Supreme Court has got jurisdiction, pecuniary or territorial, but it appears that it has no power for exercising the jurisdiction conferred upon it. Then in that case, the Parliament can make under Article 140 a law conferring supplemental or incidental powers, ancillary powers. Then the question arises whether the judgments or orders of the Supreme Court are final or not. Article and on whom these are implementable and applicable. Article 141 says, the law declared by the Supreme Court shall be binding on all courts within the territory of India. This is important. First, you must understand whether Supreme Court has declared any law. If it declares any law by way of its judgment or orders, then on whom it is binding? It is binding on all courts. All courts means, where are those courts? The courts which are within the territory of India. That is important. This is Article 141. It says, Article 141 says that the law declared by the Supreme Court is binding on all courts within the territory of and these orders or decrees are implementable by whom? By all. Who are all? All authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court. No authority, whether civil or criminal or judicial, whosoever he may be, cannot say, I will not assess the Supreme Court to implement its order or decree. Article 141 says, everybody, that means all authorities, civil and judicial, who are there in the territory of India, they must aid the Supreme Court. So, what we have to see is so these orders or decrees of the Supreme Court shall be implemented in the in the territory of India by all courts and also all authorities, whether they are civil and judicial, who are there in the territory of India. Then Supreme Court has got power to make rules of the court under Article 145. And under Article 146, there is a provision regarding expenses of the officers and servants. So with this, I spoke generally about various provisions about the establishment and constitution of Supreme Court and how the judges of the Supreme Court have to be appointed and what are the powers of the Supreme Court, and also the law declared by the Supreme Court is the law of the land. It shall be implemented within the territory of India by all the courts and all the authorities, civil and judicial, must come in aid while working or implementing the judgments or orders of the Supreme Court. With this, let us go next about high courts. How an high court has to be established, how it has to function, what are the powers of a high court. Chapter 5 of the Constitution of India deals with high courts in the states. High courts in the state. The high courts of the states. It clearly says 214. There shall be a high court for each state, and every high court shall be a court of record, and it also has got, like Supreme Court, all the powers of such a court, including the power to punish for contempt of itself. Then Article 216 says, every High Court shall consist of a Chief Justice and such other judges as the President may from time to time deem it necessary to appoint. This is very important. Though there are certain principles about deciding about the strength of the judges, but ultimately it's the President of India who acts as per the advice of the Council of Ministers, Central Ministers, to decide about how many judges have to work in a particular state. But otherwise speaking, there shall be a High Court for each state, and it consists of a Chief Justice and other judges as the President of India from time to time may deem it fit to appoint. And the power of High Court is, it's a court of record, and it has got all powers of such a court as a court of record, including the power to punish for contempt of itself. Then let us see what are the conditions of the office of a judge of High Court and who will appoint. A judge of the High Court shall be appointed by the President of India under his seal, under his hand and seal. Then condition is that judge will act until he attains the age of 62 years.
Excuse me, sir. Shall we join
And a
again?
judge of the High Court,
Shall we join again, sir?
unless he is a citizen of India, can be appointed. Same qualifications like for a judge of Supreme Court, but a distinguished jurist cannot be appointed, as the case of appointment of judges Supreme Court as High Court judge. Either he must have had a practice of 10 years in judicial office in the territory of India, or 10 years as an advocate of High Court.